Welcome everyone to the webinar on the enforcement of a mandatory vaccination policy. My name is Philip Kruger, and I'm joined this morning by my colleague, Alliance Ndlovu, and we are both from the legal department at RSM. Now, this is our second webinar, and I think I'm going to dive right in and start by saying the Consolidated Direction on Occupational Health and Safety Measures in Certain Workplaces, or the OHS Direction, which we dealt with in our first webinar, really already emphasizes that employers should recognize objections to vaccination of employees on two grounds. And those two grounds would be medical and constitutional grounds. So it's really then advisable for a vaccination policy to make express provision for a detailed objections process whereby employees' concerns could then be considered. Now, the Code of Practice, much like the OHS Direction, also recognizes that some employees may refuse to vaccinate. So in these cases, what the code requires is that the employer must counsel the employee, and if requested, allow the employee to seek guidance from a health and safety representative or a worker representative or even a trade union official. And if after such counseling, the employee still refuses to vaccinate, the employer must then take reasonable steps to accommodate the employee, bearing in mind that where the basis for the employee's refusal to vaccinate is that the employee has a contraindication for vaccination, which has indeed been confirmed by way of a medical certificate, or if deemed necessary, an evaluation conducted at the employer's expense, the employer must then accommodate that employee. And it's only then really where reasonable accommodation is not possible without causing unjustifiable hardship to the employer, then the dismissal of the employee can be considered. Now, reasonable accommodation is a fairly well-known principle in our law, and it's really one that employers should always consider. In addition, before an employee can be dismissed, they must be afforded the opportunity to be heard, which is also a very well-known administrative law principle applicable in the South African law. Now, in this regard, there has been various case law where the CCMA has held that the dismissal of employees refusing to be vaccinated in terms of a mandatory vaccination policy was indeed fair. And Alliance, perhaps you can take us through some of the detail of these cases and illuminate the considerations that led to these decisions.
Thank you so much, Phil. So today in our second webinar, we're gonna be looking at three different cases. There's quite a number of cases that have went to court, to the CCMA as well as the Labor Court. But unfortunately, most of the cases that went to the Labor Court, they were never decided because most of the employees who took their employers to the Labor Court, they went on an urgent basis, and as a result, the court struck most of those matters for lack of agency. And as we are here today, we don't really have a Labor Court judgment in that regard. I will be looking at three various judgments or decisions from the CCMA. The first that I'll be looking at deals with the dismissal of an employee who refused to vaccinate. The second one will be dealing with the suspension of an employee who is more or less the same. It relates to the mandatory vaccination policy. The third one that I'll be looking at will deal with retrenchment of an employee who still refused to vaccinate. And the third one also touches base on the issue of severance pay. The first case that I'll be looking at is a case of TM versus Gold Rush Group. In this particular case, Gold Rush had implemented a mandatory vaccination policy, which it had implemented after it had a consultation with its employees for a period of 3 months. And this particular policy was implemented in terms of the direction, which has since been abolished with the end of the national disaster, as we previously discussed in our first webinar. However, when the employer implemented the mandatory vaccination policy, one of its employees refused to be vaccinated in terms of the policy, specifically relying on Section 12 of the Constitution, which provides for the right to bodily and physical integrity. In our first webinar, we dealt extensively with the issue relating to the constitutional ground upon which employees can actually rely on to refuse vaccination. However, we indicated that even if an employee wants to rely on any constitutional ground, there has to be legitimate reasons, because the rights that are enshrined in our constitution are not absolute. They are subject to limitations, provided that the limitation is justifiable in terms of Section 36 of the Constitution. In Gold Rush, the employee then sought to rely on a right which has been provided by Section 12 of the Constitution and raised an objection to the vaccination in terms of the policy. Luckily enough, Gold Rush had all its ducks in a row, because it had already created an exemption committee in terms of the policy, which its role was to consider any objection which an employee or other employees might raise insofar as vaccination is concerned. The exemption committee considered the objection which was raised by the employee, and they declined her application. And the basis for declining her application was that she was deemed as a high-risk individual with daily interaction with other staff members, owing to a position as a business-related and training officer. We mentioned in our first webinar that when employers seek to enforce this mandatory vaccination policy, of course, they need to have regards to the nature of their business. It's not a one-size-fits-all. They also need to consider the issue relating to the role that the particular employee occupies at that particular employer. And this goes back to the issue of the reasonable accommodation, to try and see if an employee can be accommodated or not without any undue hardship to the employer, as Phil has already mentioned. Following the refusal by the exemption committee, there was an incapacity hearing which was held at the employer premises. And at the hearing, the employee was found to have been permanently incapacitated as a result of a failure to vaccinate, and also as contravening her obligation to participate in the creation of a safe working environment. The issue of creating a safe working environment, this is a right which, or an obligation which has been imposed to the employer as well as an employee in terms of the Occupational Health and Safety Act. The chairperson of the inquiry, this was the internal inquiry, further found that since the employee indicated that she had no intentions at all of being vaccinated, her incapacity was permanent, and as a result, her employment was terminated. Following the termination of her employment, she then approached the CCMA for a determination of the substantive fairness of a dismissal. The commissioner at the CCMA considered the process which was put in place by Gold Rush prior to reaching the conclusion of her incapacity, which was said to be permanent, and as a result, she was dismissed. And by having regard to the reasoning which was provided by the exemption committee, which was related to the position which she was holding and the fact that she was regarded as high risk because she was interacting with most staff members of Gold Rush, the commissioner found in favor of Gold Rush and found that the dismissal was both procedurally and substantively fair. And as a result, the employee was found to have been permanently incapacitated. The issue relating to the permanency of an incapacitation, it went back to the fact that she had no intentions at all of wanting to be vaccinated. In addition to that, the CCMA also found that the employee has failed to assist Gold Rush with creating the safe working environment which is provided for by the Occupational Health and Safety Act. I think one big lesson that we get from this case of Gold Rush, it goes back to the issue of when an employer seeks to enforce a mandatory vaccination policy, it needs to first consider whether or not is it possible to reasonably accommodate the employee. And in so doing, they need to consider also the role that the employee plays in the company, the interaction that the employee has with other staff members or clients of the employer. In addition to that, it needs to be considered on whether or not the employee can be able to execute his or her role at home, or are there other alternatives which can be considered. I will then move to the second case that I will be looking at, which relates solely to an issue of a suspension, which is the case of Koch versus Daca Securities. In this case, the employee who was Koch, he referred an unfair labor practice dispute, alleging that his employer, who was Daca Security Services, suspended him unfairly, and that the suspension amounted to unfair labor practice. In this particular case, the employee was instructed to return to work only once he had been vaccinated for COVID-19. Alternatively, he was requested to provide a weekly COVID-19 test results, which had to be negative. In this particular case, the instruction on the issue of the vaccination did not come directly from Daca. Of course, Daca is the one that then had to pass the message to its employees, but the reason why Daca requested its employees to be vaccinated, and it requested that if they don't want to be vaccinated, the alternative was for them to provide a negative test results, was because Daca was working at the premises of Sasol. Sasol was one of the primary clients of Daca, and Daca was operating at those premises of Sasol, and Sasol required that every person who has access to their premises, they have to be vaccinated. And if they are not vaccinated, they were required to provide a weekly negative test results. In this regard, the employee refused to get vaccinated. And at some point, he refused to provide weekly COVID-19 test results due to the cost of actually doing so, because the cost of that were from his own pocket. Following that, his access card to accessing the premises of Sasol was then blocked, and he was not able to access the premises. And as a result, he then approached the CCMA and said that he was unfairly dismissed. And his refusal for vaccination, he had based it similarly with the case of Gold Rush. He had based it on the Section 12 right, which is provided by the Constitution. And in addition to the Section 12 objection, he had also raised the issue of the fact that he is a Christian and he had recovered from COVID-19 in the past when he stopped taking the medication, and instead he relied on his faith and his body natural immune system. In this particular case as well, one of the things that we learned, it goes back to what I've already alluded to about considering the role that the particular employee plays at the employer, as well as the risk that is there insofar as other employees or customers of the employer are concerned. In this specific case, Mr. Koch, he worked in the front line, and he was an essential worker who was working very closely with other employees as well as members of the public as a safety officer. And the employee, when he took the matter to the CCMA for the unfair suspension, that's exactly what the employer alluded to the commissioner, the fact that the employee is very high risk because he engages with most of the employees at work. He shares an office with other employees, and also he shares, he engages with other members of the public. There were various alternatives which were considered in this regard to see whether or not the employee can be accommodated, of which one of them, it related to him working from home. But because given the nature of his work, those alternatives that were considered were impractical. And as a result, they could not be applied in his instances. The CCMA then had regards to various factors to come to a conclusion of whether or not his suspension was substantively fair. One of the things that the commissioner made findings on is the fact that the public interest outweighed the right to bodily and psychological integrity of certain individuals. In this instance, it was Mr. de Kock. Also, the commissioner found that the vaccination has shown a demonstrable success in limiting severe illness and transmission. And the aim of vaccination was to ensure a safe working environment for everyone and to protect the livelihoods of the employees as well as the customers of Sasol, including the employees of the employer who was Daca Securities in this instance. Amongst others, the commissioner went further to say that the requirement to vaccinate was a reasonable practical step that every employer was required and compelled to take in terms of the Occupational Health and Safety Act. The commissioner considered also the point or the objection that the employee had raised insofar as his Christian belief is concerned. However, the commissioner found that in as much as the employee raised that particular point as a defense or an objection for him to get vaccinated, he did not produce any evidence whatsoever to justify that particular relief. As a result, the commissioner found that he failed to prove that it is a requirement of the Christian belief that a person should not be subjected to vaccination. And based on all those reasons that I've mentioned, amongst others, the commissioner in that particular case of Koch versus Daca Security and Services found that the suspension was substantively fair. Two things that we learned, and I think I've already mentioned them with the de Kock case as well as the Gold Rush case. It's the issue relating to reasonable accommodation. As an employer, one of the cautions that we always allude to is the fact that you cannot just simply implement a mandatory vaccination policy and dismiss an employee simply because they are refusing to vaccinate, because you are required as an employer to first ascertain whether you have the means upon which or alternatives which can be considered to reasonably accommodate the employees. Because as Phil has already mentioned, the issue relating to reasonable accommodation, it's a well-known principle in our labor law, and employers are required to consider other alternatives that are there to the extent that those alternatives can be used and they are workable, taking into account the role that the particular employer occupies as the employer and the business that the employer is engaged in. The last case that I am going to be looking at, it's the case of Cecil Basic versus Baroque. This is the case that I mentioned, which relates to a retrenchment as well as a payment of severance pay. This is also a CCMA decision. In this particular case, the commissioner found that a retrenchment of an employee as well as a non-payment of a severance pay of an employee who refused to comply with a vaccination policy was fair. Briefly, if I can just take you through the facts of this particular case, is that the employer, who is Baroque, he supplies medical devices to various parties in the healthcare industry and is classified as an essential service. Given the nature of the employer's business, the employer then went on to implement a mandatory vaccination policy in line with the Occupational Health and Safety Act, as well as the direction at the time that applied. And now we know that it is the code that Phil referred to that will be applicable. The employee, who is Cecilia Basic, she refused to comply with the mandatory vaccination policy on various grounds. It was 3 grounds that she relied on. It was medical, personal, as well as religious grounds. She further declined to be vaccinated, just like or similar to the Gold Rush case, as well as the Koch case. She also relied on the Section 12 of the Constitution right relating to her bodily integrity. The employer in this case recorded that despite providing reasons for her unwillingness to vaccinate, the employee failed to provide sufficient evidence to support the reasons for her unwillingness to vaccinate. Just like in the other two previous cases, the employer did not just simply retrench or dismiss the employee on the basis of the employee refusing to vaccinate. The employer had to consider various alternatives which are there. However, the alternatives which the employee considered were, the employer considered were very impractical given the nature and the role of the employee at the employer's premises. And pursuant to a consultation process which took place in terms of Section 189 of the Labor Relations Act, the employee was then handed down a notice of termination of employment, and the employee was subsequently retrenched. The employer argued that considering the position that the employee had at the employer, her duties were of such a nature that she had frequent contact with colleagues who engaged with third parties in the healthcare industry. And furthermore, as an essential service provider, the employee had high exposure to the virus, given the nature she performed and the office plan set up. And as a result, she was considered as the risk of transmission was considered to be high. And as a result, the employee was required to vaccinate, failing which the employer had to do what was necessary to create a safe working environment at the workplace as obligated by the Occupational Health and Safety Act. And in this regard, the employer opted to proceed with the Section 189 process and retrenched the employee. The employee then took the matter further and went to the CCMA. And the commissioner at the CCMA found that the risk assessment, which was considered by the employer during its implementation of the mandatory policy, although it was not challenged, that was found to have met the requirements which were set in the Occupational Health and Safety Directive or Direction. The CCMA further found that the employer established a case and a clear business rationale for retrenching the employee for the following reasons. One of the reasons was that the employer had provided a clear rationale for the imposition of the mandatory vaccination policy, given the nature of the work that the employer engaged in. Secondly, the commissioner found that the mandatory vaccination policy was necessary to ensure that the operations of the employer were not severely affected by absence of employees as a result of employees contracting the COVID-19, and also to protect third parties who then would interact with the employer's employees, who these third parties could be the clients of the employees. The last point which the commissioner also dealt with in justifying that the employer had followed due process and had made out a clear case was the fact that the employer had embarked on an appropriate risk assessment of its position and duly justified why it was necessary to impose a mandatory vaccination policy as a justifiable operational requirement. The issue relating to the appropriate risk assessment, we dealt with extensively in our first webinar, where we advised that before a mandatory vaccination policy can be implemented, the employer is required to embark on a risk assessment to be able to justify the necessity of implementing a mandatory vaccination policy in the workplace. In this particular case as well, the CCMA went further and found that there was evidence or there was insufficient evidence by the employee which could justify or sustain her objection. And it was accepted that whatever alternative positions which were provided to her ultimately were all going to lead to require the employee to vaccinate, given the nature of the employer's business and the role that the employee occupied at the employer's business. The CCMA did not only end there insofar as it found that the retrenchment was justifiable. The CCMA went further to consider the issue relating to a severance pay as to whether or not the employee should be paid a severance pay given the retrenchment that took place, which the CCMA found to have been justifiable. In this regard, the CCMA considered Section 41.2 read together with Section 41.4 of the Basic Conditions of Employment Act. which provides that an employee who unreasonably refused to accept an employer's offer of alternative employment with that employer or any other employer is not entitled to severance pay in terms of Section 41(2). Having considered that those particular provisions of the Basic Conditions of Employment Act, the CCMA found that the employee's election in this particular case to refuse to vaccinate was very unreasonable and were without merits. And in that regard, the CCMA accordingly found that it would be unfair to require the employer to pay the severance pay in circumstances where the employer's actions were unreasonable and without merits. So we see those are some of the cases that we have seen that have come up in our CCMA relating to the issue of the enforcement of the mandatory vaccination. And one of the things I think that are coming up in all the cases, the three cases that I've covered, it's the issue relating to employers embarking on a good, reasonable measures to accommodate employees to the extent that they can accommodate the employees, and not to take the issue relating to the mandatory vaccination policy as one which fits in all circumstances. The employers would be required to consider the nature of their businesses and consider the role of the employees. To the extent that the employers can be able to accommodate employees, they should do so. Phil, I think I'm going to hand over to you now to just touch base on some of the things that I might have left out.
Thanks, Alliance. Thank you very much. And yeah, Alliance, I think you're quite right. I think, you know, from what you've said and really from what we've seen happening in the CCMA, in the media, from conversations even that we are having with friends and family, it's really clear that employees refusing to vaccinate will continue to be a challenge for the validity of employers' mandatory vaccination policies. I think at this point in time, it's rather unfortunate that we don't have a definite judgment from a higher court as yet. And with that sort of uncertainty, it's really imperative that employers ensure that they are able to justify the need for such a policy. And then further to that, would ensure that any vaccination policy that's implemented is done so in strict compliance with the Occupational Health and Safety Act and any other regulations that would be applicable. And I think employers, as you rightly have pointed out, Alliance, should guard really and should be advised against taking a blanket approach to dealing with cases where employees refuse to comply with these mandatory vaccination policies. And it's purely because there may be cases where employees indeed have legitimate reasons for refusing to comply with vaccination policies. And there may also be viable and available alternatives to accommodate those employees. So whether a mandatory vaccination policy can be regarded as an operational requirement for a workplace would really depend on the unique nature of each business and should really be considered on the merits of each case. And therefore, employers will be required to show objectively that the implementation of a mandatory vaccination policy has bearing on the economic viability of their business. From our side, we would certainly encourage employers to seek legal advice before taking any action against employees for the refusal to comply with the mandatory vaccination policies, and to ensure, that they have really considered all of their options in this regard. Thank you for your participation this morning, and we'll now move to a question and answer session.
Yes, definitely. So if there's anyone with any questions, you can post your questions on the Q&A chat box, and then we will go through some of your questions.
Alliance, one of the questions that have been raised here is regarding the Constitution. And it says here, what about my fundamental rights? What about the Bill of Rights? And really that is a good question. And it's a question that comes up quite often, as we've seen in those fundamental, well, in the CCMA cases, it's really the fundamental rights that have been raised as reasons
Yes.
for not being vaccinated. What would be your view? How should the courts be dealing with that, Alliance?
Yes, so thanks for the question, Mark, that you've raised, and thanks for the person who raised the question. Mark, as I've alluded to it, so the rights the fundamental rights in the Bill of Rights are not absolute. They are subject to limitation, and the same Constitution in Section 36 provides for the limitation of the rights in the Bill of Rights to the extent that the limitation is justifiable, having regards to the purpose of the rights and the circumstances relating to why that particular right has to be limited. In this instance, for instance, we're looking at employees raising the Section 12 right to bodily integrity. We are all aware that COVID has affected a lot of people around the globe. Some people have lost their lives, and these can go back also to the issue relating to the right to life, because the other people that we're exposing them to this virus can actually contrast the virus and actually die. So the court will look at that particular right, which is your right to bodily integrity, as well as the right of the also general public and what public interest dictates. And to the extent that the public interest, and this is something that was actually considered in the case of Baroque versus the Daca Securities, because there the commissioner even made a finding that the public interest actually outweighed the right to the bodily integrity and the psychological integrity of that particular employee in that particular case, given the consequences of what we know COVID can do to other employees and other general public.
Yeah, Lance, I would agree with you there completely. You know, I had a professor at university who used to say that your fundamental rights are akin to your arms, in a sense. You can only have freedom of movement to swing your arms until you hit the person next to you. So until you start really infringing on their rights, sure, you can rely on your fundamental rights. But the moment that you exercising a fundamental right starts infringing on somebody else's fundamental rights, that's where we need to find that balance, and where Section 36 really comes into application, and where you look, you know, what type of limitation would be justifiable in an open and democratic society. So no, absolutely, I agree with that fully, Alliance. Then we have had some more questions coming in. One question here is, what about a mandatory vaccination policy for booster shots? And if so, how often? You know, my view on that would be, you know, really the only enforced vaccination that can really be applied at this point in time is the vaccinations that are available by way of the government requirements, and that's really what you can insist on from a vaccination policy point of view. I'm quite sure that we will probably see regulations and guidance coming through on that front, but I think to sort of include that at this point as a absolute requirement would maybe be jumping the gun. Your view on that, Alliance?
Yes, no, 100%. No, I agree with you. I agree with you, Phil, and that we can only work based on the vaccinations that we currently have at the moment, and what the government is basically encouraging us to actually get to vaccinate. And yeah, we can then take it from there.
Sure, absolutely. Then we have another question here. It says, if an employer has breached its own vaccination policy, would that policy still be viable, or would the organization need to amend and communicate another one? So that's an interesting question. You know, from the get-go, I'd like to sort of say that it's probably an indication of a problem with governance if you are breaching your own policies that you have set. By the same token, I think it's important to see what the breach indeed would be. I mean, if it is a breach that really strikes to the heart of the policy, then just from a natural justice point of view, I would think it would be hard for an employer to enforce rules that they are not uniformly applying, and indeed not applying themselves then. So I think that would be problematic. Whether it would completely throw the policy out, and whether you should reestablish a policy, again, I think it depends on the nature of the breach. But from my perspective, certainly, I think there would be governance issues there, and further to that, I think it would be difficult for the employer to successfully apply a policy if the employer cannot be seen to be applying it fairly on everyone.
100%. I agree with you, Phil. I think the employer would also have a problem if they were to go to the CCMA to try justify the applicability of that particular policy if they are also breached. And as you said, I mean, it goes back to the heart of the governance of the company. Phil, right on that, I see a follow-up question relating to what we actually just discussed now, which basically says that is it fair, or would it be unfair that a mandatory vaccination policy would apply to some employees, and to some employees it would not apply in the workplace? Is it advisable to have a mandatory vaccination policy? However, it applies to some and does not apply to some employees. My view to this, I think it goes back to the issue of reasonable accommodation, where the employer, when it does its risk assessment, it will be able to identify those employees who are considered high risk and those that are not. And given the nature of the business of the employer, as well as the role of the various employees, the employer will be able to consider the alternatives, because the alternatives comes into play when the employer has to consider how to accommodate the employees. Of course, there could be some employees who can possibly work from home and there is no issues with that. However, given some employees' roles, they can't work from home. They have to interact with other staff members, or they have to interact with customers of the employer. And in that regard, they would have to get vaccinated. I don't know what your view is on that.
Yeah, Lance, I think that's spot on. And, in addition to that, I think it's also just sort of a logical question as to what do you do? What do you do for a living? What does your job function require? And we saw the CCMA apply that indeed in the Koch case, as you mentioned. One of the considerations was that Mr. Koch works with other people, interacts with other employees, and also he's a frontline sort of face of the business employee who sort of dealt with the public quite often and with the customers. So, it's one of those issues that employers would really have to look at carefully in terms of saying, well, if we are identifying certain positions that we view as critical positions and positions that do interact with the public and that would require a mandatory vaccination requirement, that is fine. It doesn't mean to say that every employee then falls within that policy. However, that policy, if you then do adopt a policy to say that employees who are sort of client-facing, who are at the front line, who meet certain requirements, if you then treat two employees in that very same position differently, that would be a problem. So if you have two employees who are both dealing with the public, who are both frontline, who are both sort of in high-risk positions, they should be treated equally in terms of that policy. And it's on that level that really it should be uniformly applied. But of course, in that risk assessment, it actually requires you to look at which employees should be subjected to this policy and which wouldn't.
100%. I think we have another question. And it says, can an employer require unvaccinated employees to undergo weekly PCR testing and not vaccinated employees, even though they can also become infected with COVID-19? What are your views on that, Phil?
Yeah, I do think that an employer could in fact rely on the fact that if you are an unvaccinated employee, that you should undergo weekly PCR testing. And then, it's perfectly reasonable for the employer to put that as an alternative in respect of vaccination. Yeah.
Yeah, no, I completely agree with you, Phil. I mean, it's something similar to basically what happened even in the last case that I dealt with, because the alternative that was provided is you get vaccinated. Alternatively, you provide your weekly COVID-19 test results. So yeah, it is an alternative, because that can be considered as an alternative to that.
Okay.
There is also a labor court judgment which dealt with an admission policy, where the court even considered that issue of employees producing the negative results at the workplace for them to be able to access the premises of the employer.
Absolutely. No, quite right, Elias. I agree there. And in addition to that, it didn't really form part of the question, but a follow-up question to that could very well be, what about the cost of those tests? Should the employer be on the line for the cost of those tests? And I think for that, it really then strikes back to that requirement of not placing a sort of unjustifiable burden on the employer. The employer would be well within their rights to want to cater for a safe working environment. And
yes,
even one of the measures that they implement would be these PCR tests. It may very well be that it would place an unjustifiable burden on the employer if they were expected to pay for these tests. From a logical point of view, the vaccinations are free. So your alternative would be, you don't have to pay for the tests as an employee if you are vaccinated, and that you can be vaccinated at no cost. So I think in respect of the costs, that in my view, it would be justifiable from an objective point of view that the employees would shoulder that cost.
100%, Phil, 100%. And actually, the question that you just dealt with, it's something. It was a follow-up question, and you are 100% correct, Phil. I mean, when looking at the case law in the same labor court judgment that I referred to, I mean, the court did not even get into too much detail or making a finding as to who should bear the cost. But yes, I completely agree with you that it goes back on the issue of not putting too much burden on the employer. So yeah, well, that's it from me, Phil.
Perfect. Lance, I think spot on. We are starting to run a bit short on time. So I think we can wrap it up here. And I would like to thank everyone for listening. And I would like to thank you as well, Alliance, for joining me on the webinar. And we'll see you next week.